the Equality Commission for Northern Ireland and the Health and Safety Executive for Northern Ireland. As we know, trade unions have been reporting persistent issues for pregnant women and women on maternity leave throughout the pandemic, and in the early months, many of these related to women being incorrectly sent home on statutory sick pay. And other issues arose where employers were insisting on women being in work despite the union's insistence that the workplace was not safe and public health guidance. And we also know that PPE connected, issues connected to PPE were PPE not suitable for pregnant women and other vulnerable workers. So that's why we thought it was so important to bring our agencies and speakers together this morning. So just before we kick off with the presentations, I want to make a couple of brief housekeeping points. First of all, to say that we are going to be recording the session this morning. We're going to be recording the presentation part of the webinar. So just if you don't want to be featured on that, if you wish to turn off your video, free to do that. We're not going to be recording the Q&A session afterwards. We will make the recording available to you, and we'll be in touch with regards to where that will be available. And the speakers have also very kindly agreed that their slides can be circulated afterwards. So time allowing, we will get to Q&A after the end of the presentations. So if you want to post your questions in the Q&A, then we can look at those afterwards. If we don't have time, because as we all know, these things can run over time. So if we don't have time, please get in touch with either myself. You should have my email address and details, or if you don't have mine, get in touch with Tony with your questions, and we will come back to you and endeavour to get you an answer to you. So I'm going to stop there. I'm going to introduce our three speakers all together and welcome them. Helen Smith from the Labour Relations Agency, Una Wilson from the Equality Commission for Northern Ireland, and Sue Spence from the Health and Safety Executive. And I'd also like to welcome Sue's colleague, Martin Rafferty, also from the Health and Safety Executive, who's there with her as well. So each speaker is going to speak for about 15 minutes. Then we're going to have a very brief comfort break, after which hopefully we'll have time for some questions and answers. So I'm going to hand over to Helen now.
Thank you, Claire. So I'll just wait for Tony to put up the slides. Thank you, Tony. If you can just hold it there, I'll ask you just to move it forward whenever I'm ready. In this short session, I'm going to provide a whistle-stop tour of those key areas relating to pregnancy and maternity during the pandemic from an employment law perspective. There may be some duplication with the information I share, although I will do my best to keep this to a minimum, so to allow partners from the Equality Commission and Health and Safety Executive to pick up on their specific areas of expertise. We are all well aware of the damage the pandemic and now the threat of variants is having on our local labour market and economy. 1 year on, we are still witnessing hastily cobbled together guidance with legal effect, which is amended frequently. This has been a headache for employers, HR practitioners, trade unionists, lawyers, and anyone involved in the realm of employment, throwing up more questions than there are answers, and the courts have not been operating to see how these are to be legally interpreted or construed. This has brought about great uncertainty and instability for many workplaces. Next slide, please, Tony. Thank you. So what special considerations apply where the employee is pregnant? Employers have additional duties to protect the health and safety of new and expectant mothers in the workplace. And in summary, the law requires employers to assess the workplace risks posed to new or expectant mothers or their babies, temporarily alter the employee's working conditions or hours of work, or if that is not reasonable, offer them suitable alternative work, or if there is none available, suspend them from work on full pay for as long as necessary to avoid the risk, although furloughing the employee on full pay is also an option for employers that are making use of the coronavirus job retention scheme. On the screen, you will see abstracts from the Employment Rights Northern Ireland Order 1996, and those are the specific articles which contain the summary of the law I have provided for you. And Tony has the link to share with you after the session this morning. The government, with input from the Royal College of Obstetricians and Gynecologists and the Royal College of Midwives, has also published a short guidance note aimed at pregnant employees. The guidance reiterates the importance of adequate risk assessments and makes a number of recommendations, and Tony will also share that link with you after the session this morning. It is important to be aware that any alternative work given to a pregnant employee should be suitable and appropriate for them to do in the circumstances, and on terms and conditions not substantially less favourable than their normal terms and conditions. The suspension of a pregnant employee on health and safety grounds during the coronavirus pandemic must be on full pay. As an alternative to suspension, the employer can furlough a pregnant employee under the coronavirus job retention scheme until their maternity leave starts. To avoid the risk of discrimination, the employer should top up the employee's pay so that they are paid in full during their furlough. Next slide, please, Tony. Thank you. There are two infrequently used pieces of legislation, and in current circumstances, there is the potential we will see more claims of this nature coming down the tracks. These relate to health and safety dismissals and detriment claims. The legislation provides the employee with the option of unilaterally leaving or proposing to leave or taking steps if they have reasonable belief they are in circumstances of serious and imminent danger and it cannot reasonably be controlled, then any dismissal would be automatically unfair. The employee may be able to claim compensation for any punishment, such as the non-payment of wages, although any case will be highly fact-dependent. There are some cases likely to be made where the employer's instruction is reasonable from their perspective, provided they are seen to be following government guidance, and the employee's refusal to attend the place of work, fearing serious and imminent danger, may also be reasonable from their perspective, having assessed the risk as not adequately controlled, even if all the guidance is followed. In employment law terms, that leaves both employers and employees with difficult conversations about what steps they take in such circumstances. The best answer in these circumstances is for employers to follow the guidance, set up and implement all protections that they reasonably can. Then they should consult, negotiate and agree the measures with the workforce, and if there is a recognised trade union representatives should be fully engaged. Again, this offers no immunity from legal redress, but offers the best way forward. Each case will be fact specific. Can an employer require a pregnant employee to start their maternity leave early? Starting maternity leave early became an issue for many people at the start of lockdown, as employers were working out how to deal with the economic implications of workplace closure or a downturn in business. It may well become an issue again in the event of further lockdowns or other economic impacts of COVID-19. An employer cannot force a pregnant employee to start their maternity leave early. An employee's maternity leave will be triggered if they are absent from work for a pregnancy-related reason, including a suspension on health and safety grounds in the 4-week period before their expected week of childbirth. In all other circumstances, including where the employee is off sick for a non-pregnancy related illness, her maternity leave must start on the employee's chosen start date as notified to the employer. To attempt to force an employee to start her maternity leave earlier could be discrimination on grounds of pregnancy and maternity. Can an employee on maternity leave come back early if she is needed at work and then go back on leave? Well, in some cases, in some workplaces affected by a high number of COVID-19 related absences, or where the workload increased due to COVID-19, for example, the healthcare setting, the employer may be tempted to ask an employee on maternity leave to come back early, either permanently or temporarily, to cover the crisis. The legal implications are as follows. An employee has the right to up to 52 weeks maternity leave. They can choose to come back early on giving 8 weeks notice, or less if the employer agrees. An employer cannot require them to come back early or earlier than their chosen return date for any reason. They also cannot threaten to punish an employee for exercising their statutory rights in relation to maternity leave. This would amount to unlawful discrimination. An employee can also work for up to 10 keeping in touch days, or also known as KIT days, without bringing her statutory maternity leave to an end. Whether and how she uses those KIT days is a matter for agreement between her and the employer. There have been no changes to the legislation that would specifically enable an employee on maternity leave to help her employer during the COVID-19 outbreak over and above the 10 KIT days or keeping in touch days without ending her maternity leave and the statutory protections that go with it. However, one way of getting around the inflexibility of the maternity leave provisions is for the mother to convert any remaining maternity leave into shared parental leave if she chooses to do so. Now, this can only be done if the mother meets the eligibility criteria, and this includes getting a declaration from the employee's partner that the partner agrees and that the partner meets the necessary earnings test. Converting the maternity to shared parental leave enables the mother to take it more flexibly. For example, she may agree with the employer that she will work for, say, 8 weeks to cover an immediate crisis and then take a period of shared parental leave. This would, of course, require her to find childcare for the period at work, either by the partner taking some shared parental leave or by finding some other form of childcare. Switching to shared parental leave also gives rise to a further 20 keeping in touch days, also known as split days, on top of any keeping in touch days taken during the maternity leave. The main limitation on using shared parental leave, however, in this situation is that it cannot be extended beyond the child's first birthday. So can an employee on maternity leave be furloughed? Employees wishing to end maternity leave early in order to be furloughed must give their employer the statutory 8 weeks notice and cannot be furloughed until the end of that 8 weeks. How should an employer manage pregnant employees and those on maternity leave in a redundancy situation? Well, the employer should ensure that it includes employees on maternity leave in the redundancy consultation process. It must also ensure that any selection criteria are objective and non-discriminatory and applied fairly. This means, for example, excluding any absences due to pregnancy or pregnancy-related reasons where absence is one of the selection criteria. The employer also needs to take into account that an employee who is made redundant while on maternity leave has special rights relating to be offered suitable alternative work. A written statement explaining the redundancy or dismissal must also be provided. And once an employee has qualified for statutory maternity pay, they will be eligible to be paid for the full period, even if they are made redundant before or during the maternity leave period. And finally, COVID-19 vaccination in the workplace. The taking of the vaccine is not mandatory, and ultimately it is personal choice as to whether or not an individual wishes to take it. Pregnant employees may have valid reasons to refuse the vaccine and should seek advice from their GP or midwife in the first instance. It is worth remembering that the vaccine is just one measure of protection, and employers must follow the public health advice and comply with the relevant regulations as they continue to apply. For an employer to compel an employee to take the vaccination may well be covered by the anti-discrimination legislation, depending on the specific facts of their case, and may well be able to seek legal remedies. So that really comes to the end of the presentation. Tony, if I could just ask you to move it to the next slide. Thank you. And if any of the colleagues here today have any employment-related questions, specifically relating to pregnancy and/or maternity, well then please feel free to contact our Workplace Information Service. The details are there on the slide for you. And thank you for your time.
Thanks very much, Helen. I'm now a very comprehensive presentation, and I'm sure there will be some questions either now. I see Brian Hewitt from Unite has already posted a question in the chat. I'm going to turn now and invite Una Wilson from the Equality Commission to make a presentation on the equality law perspectives. Thanks, Una.
Thank you, Claire. Good morning, everyone, and thank you very much for the opportunity to speak this morning. I'm going to, obviously, Helen's covered a lot of issues where there's overlap between employment law and equality law issues. So I'm going to focus in more on certain issues. There's a lot of slides, but they're more for reference purposes. So I will be skipping through some of them fairly quickly. But I do want to bring up the context in which in the last 3 weeks, 50% of all advice calls to our legal division have been around sex discrimination. And also in the context of that, we're seeing increasingly numbers of calls to do with maternity and pregnancy within the workplace. So I'm sure that's of interest. And it follows through on the research that Unison carried out around pregnant workers and new mothers returning to workplace, that there has been disproportionate discrimination despite the law, and that contrary to the fact that we've both ourselves, the Equality Commission carried out a formal investigation in 2016, and the Equality and Human Rights Commission, our sister body in Britain, also carried out a formal investigation, and the issues seem to be fairly similar. I'm not going to focus too much in on the health and safety issues because I know Susan will be covering that in her seminar. So next slide, thanks, Tony. Just to give you an indication that that's our website and that's where you'll find information. Obviously, I'm only going to be giving you a whistle-stop tour this morning, so I'm just going to move on. Next slide, Tony. Some of you are aware, probably in the context of this, that the women have been more likely than men to work part-time and make up 58% of those in involuntary part-time employment. Women were the majority on temporary contracts and zero-hour contracts. Female employees were more likely than male employees to be working in jobs where the poor and in terms of certain sectors which have been adversely affected across the economy in terms of retail and in terms of different areas, but obviously taking into consideration the issues that you may be representing individuals. The Institute of Financial Services has said that found mothers were 10 percentage points more likely than fathers to be asked to be furloughed. So this goes back to some of the information that Helen was given in terms of furlough. I will give you a link at the end of our seminar too, and Tony will be able to send you the links to our pregnancy note and COVID-19, which identifies a lot of the issues that Helen has already spoken about. In terms of equality legislation and how it impacts. But do think about the context that they are now saying that this present pandemic is probably going to put us back around 10 years in terms of gender equality, and thinking about the inequalities that the Equality Commission has identified, where pregnancy and discrimination has continued to be one of the foremost issues that we are addressing and trying to address. Next slide. Okay, so this was the informal investigation that we carried out, and I think it's really crucial in terms of looking at this issue, in terms of what types of discrimination were identified. And the primary issue was no health and safety risk assessments. So in the context of a COVID-19 pandemic, that's crucially important. Although this research was from 2016, it is the research is coming through from various organizations that no health and safety risk assessments are being carried out. The other issue is that individuals' roles are being changed, and this can be in the context of so for instance, where individuals are working from home, they've got children, hours of work are being reduced for individuals against their wishes, and I'll bring some examples of some cases that have come to issues. Just something aside, but I think crucially important, you know, women who are pregnant or on maternity leave are under increased pressure in terms of their access to health services is being changed enormously in terms of pregnancy, in terms of being accompanied by a partner. And this is causing, obviously, untold stress on the individuals in terms of their mental health, and some of the statistics are quite startling in terms of individuals being adversely affected in terms of those issues. Okay, next slide. So most of you are aware of the fact that as women, individuals who may access protection under the maternity, under the sex discrimination legislation, but also in the context of that women can also be from the Black minority ethnic groups in terms of the race relations order, in terms of people from different sexual orientations also being covered, but also people who have disabilities who would meet the definition of a disability under the DDA. So bearing in mind all that women don't have one single identity, that they have lots of identities that you need to keep in mind. Next slide. So in the context of the sex discrimination legislation, in terms of it is unlawful pregnancy discrimination to treat an employee less favourably on the grounds that she is pregnant for a reason relating to her pregnancy and because of an illness relating to her pregnancy. Obviously, in terms of the sex discrimination legislation, you're also covered in the context of gender reassignment and also in terms of marriage and civil partnership. And how the scope of the legislation works is that it covers recruitment of new employees. So Are there questions we need to be asking about recruitment agencies in terms of bank employees or agency staff in terms of being discriminated on grounds of their pregnancy? Career development opportunities in terms of access to training, transfers and promotions because of their pregnancy or because of their maternity. Work environment, the prevention of harassment issues, flexible working arrangements, which I will get to in the context of indirect sex discrimination, and obviously the termination of employment. And I suppose one of the key issues that all the unions and all the research is showing is the high prevalence of women being chosen for redundancy, reinforcing the stereotype of women as primary caregivers in terms of those issues. Obviously non-contractual benefits, and some of you may be aware that you know in the context of the division between the legislation in terms of equal pay legislation, and I'm not going to go through that because you get lovely seminars with our own Kieran trainer on a regular basis to keep you up to date on those issues, so I'm not going to focus too much on those. Next slide. So in terms of looking at this in the context of what is treating a woman less favourably, the statute uses this phrase, but unfavourably would probably be a better word for there's no need for a comparator. And I think that's crucially important in terms of understanding, on the ground that during a protected period, her pregnancy, or that she has exercised or is seeking to exercise a statutory right to maternity leave. So the protected period is if a woman is entitled to 52 weeks statutory maternity leave but returns to work early after 40 weeks, that is when the protected period ends. If she takes the full 52 weeks, then it ends at that period expires. This only means that it is unlawful to treat her unfavourably for pregnancy-related absences during the protected period. If she's absent after that, then she can be compared to a sick man. So the examples that have been used in the past have been around issues around postnatal depression. But don't forget that if that postnatal depression is a reoccurring condition or has lasted for a period of 12 months, she may be entitled to protection under the Disability Discrimination Act. And so if you do have any queries, be sure to talk to our legal colleagues about any protection in that context. Just want to bring up the context of IVF because some of you are probably aware that during the present pandemic, people have not been able to access IVF treatment, and therefore there may be issues that come up in the, and I'm going to refer to a case, but there is an older case which is called the Sahota versus the Home Office case, and this was an IVF case. In that the case, the implantation had occurred, but was later discovered to have failed. The Employment Tribunal held that after implantation has occurred, the woman is pregnant and thus can rely on the pregnancy discrimination provisions of the sex discrimination order during the protected period. In this case, that period ended 2 weeks after the end of pregnancy. However, this follows from a time limit within the SDO. In the context of IVF, try to get employers to move on the grounds of best practice. I mean, situations have been very, very different for individuals, and I'm going to refer to a case which you may find useful in the context of there is other European cases in terms of the Meyer case, in terms of unlawful sex discrimination to dismiss a woman because of her absences from work during her ongoing to the advanced stages of IVF treatment. And that's where you go into your special leave arrangements, and you should be talking to the Labour Relations Agency about all those sorts of issues in terms of how you cast your policies on those issues. I will go back to the context of always in the context of reasonable steps approach. When was the last time your organization reviewed their pregnancy and maternity discrimination policies? And we have an online performa on our website, which Kieran actually drafted. So you can have a look at that. Next slide. This is a case that the Equality Commission assisted in, and I suppose it's just to show you in terms of direct discrimination that, you know, it is hard sometimes to find the evidence, but in this case, the tribunal outlined 5 particular facts, and this is in the press release, which is on the Equality Commission website. The inconsistent, contradictory and unclear evidence from the respondent's witness about when the season started and ended, and the start and end date of Laura and her husband, the contractual documentation and the contract signed by Laura and her husband, the lack of explanation about the insertion of an end date for their contract in contrast to other employees, the negative attitude displayed by the manager following the announcement of the claimant's pregnancy, the specific comments about the claimant having attended an antenatal appointment and being due to attend more. The full tribunal is obviously available online, and I've put in a link there, but it just goes to the show for you as, you know, in terms of working as trade union representatives, about trying to collect the information and ensuring that the verbal information and the documentary evidence add up together in the context of that issue. Next slide. This is the IVF case that I wanted to bring to your attention. It is only an employment tribunal case, so it's not an employment appeal tribunal case from Britain, but it is one of those scenarios where you think about what are the consistency and approaches of the evidence from both the claimant and from the defendant, the employer in this case. And this was a case in which the individual proved that she had been unfairly dismissed and unlawfully discriminated against because of her pregnancy. So Helen will have talked about unfair dismissal, and in the context also that she was able to prove that she had been unlawfully discriminated against by the sex discrimination legislation. So that protection against discrimination goes back to what I was already said about the protective period, which starts once the pregnancy begins. And this is where a scenario where she had told her employer from the outset that she may be taking time off. And in the 6 months prior to her going off, she had a miscarriage. She didn't take time off. She told her employer she was going to take unpaid leave and paid leave to for her IVF treatment. She wanted to return to work, even though once she had found out she was pregnant, and she had told her employer on the phone that she wanted to return to work, and he told her to take 2 months off. He later subsequently denied this in the tribunal scenario, and the tribunal was very clear that they said the evidence from Miss Caravadara was logical and substantial, whereas the information from the employer was not logical and substantial. In actual fact, never referred to the phone call, never referred to the fact that she wanted to return to work, and they dismissed her on the 9th of September of that particular year. This case, the tribunal decision was issued in 2019 on the 26th of September, but it just goes to show it was a unanimous decision of the tribunal. The claimant was automatically, and they claimed to know that the claimant was pregnant at the time of dismissal, was the denial. So bearing in mind that an individual, once they have IVF treatment, they have 2 weeks after that period of time in which they're protected, and that's to allow for time for the egg to implant in that context. I've given you the award, but it gives you an indication. Another case, next slide. This is the context in which somebody comes back after maternity leave, and there's suddenly the job they were in suddenly is less than what they had been doing. And this is a settlement, and the only reason I'm talking about a settlement is because it has been reported widely in the media. And this is when Mrs. Parks restarted work. She alleged that she had a minimal list of duties. Her name had been removed from the finance organization chart. 2 new accountants had been appointed. The hours of a colleague who had taken over some of her duties had been increased, and she felt she was denied access to finance files she needed for her work. She brought a grievance which was not upheld, and her appeal against her, this was not also upheld. A series of redundancy consultation meetings were held, and Ms. Parks was notified that she had been selected for redundancy. Her appeal against this was also dismissed. She was offered an alternative position within the organisation, which she did not consider acceptable, and she alleged that she was not considered for a post which she was well suited, which came up while she was on maternity leave. And Helen referred to that in the context of redundancy, about being offered an alternative suitable post when somebody is on maternity leave. Next slide. So I wanted to get to that in terms of redundancy and maternity because it is an area of concern that we have. I haven't really focused in too much on health and safety because I think Helen fairly covered it, and the health and safety executive will be looking at it after this, and I'm conscious I may be going over time, Claire, so tell me when I'm close to ending. So in terms of redundancy and maternity, selecting a woman who is in a protected period for redundancy is likely to be unlawful discrimination, okay? Because she doesn't have to compare her treatment with anyone else, okay? A woman on maternity leave has the right to return to the same job. So that was the Parks case before she left. An interim employee cannot be given her job, even if you think the person is a better employee. Selecting a woman for redundancy because of her pregnancy, maternity leave, or a related reason is automatically unfair dismissal, as well as being unlawful discrimination. A woman made redundant while on maternity leave must be offered any suitable alternative vacancy if you have one, and she does not need to have to apply for it, and that's crucially important, okay? In terms of the right to return to the same post after ordinary maternity leave, that does not apply to additional maternity leave. But in the context of looking at those issues in terms of redundancy and maternity, what's coming through on these issues, that businesses are using it to decide who will be the first to go, how good their attendance has been, in the context of the present pandemic, where the statistics are coming in that women spend 6 more hours than men on unpaid childcare during this pandemic, which in effect means that they've been doing a second shift. So it brings them up to 31.45 hours of childcare. Now, obviously, this has changed when the children went back to school. So it equates almost to an extra full-time job. So if the selection criteria for redundancy are based on attendance or performance, where their performance has been indirectly adversely affected by their context in which they've been caring for children, there is the potential that individuals may use the indirect sex discrimination legislation in the context of these issues. So I'm going to go next slide. So most of you are probably aware of how indirect sex discrimination works. It's often been used in the context of flexible working cases, but also in the context of individuals who may not be able to meet provisions, criteria, or practices in a proportional means of achieving a legitimate aim. And I'm going to fly through this because does it have a more discriminatory impact on the affected group? So are women, because of caring reasons, going to be disproportionately affected by the present pandemic? And the evidence points to the fact that women proportionately still carry the caring duties in the working environment. Next slide. So you all know that the objective just for flexible working, that these are the reasons why a flexible working request can be turned down by an employer. And in the context of where we've had situations where individuals have automatically moved to working from home, and some of you are in sectors where individuals had to continue working because they were key workers, you'll need to look at this in more detail in terms of whether, specifically in terms of the health sector, I suppose, is whether they're going to be using the detrimental impact on quality. But in terms of maternity and pregnancy issues, in terms of returning to work on flexible working requests, it is proportionately the employer can look at the context of, can it impact on the way in which they deliver the service, or in the context of health and safety issues that potentially could be adversely impacted if there isn't sufficient people to meet the needs of patients in different scenarios. Next slide.
Una, I'm sorry to interrupt. It's Claire here.
I haven't gone over.
Well, I just to give you maybe a couple of minutes time check, if that's okay. I'm sorry to interrupt you in full flow.
No, you're flying, you're grand. I just wanted to bring the context of breastfeeding in terms of just making sure that, you know, in terms of shift work, in terms of indirect sex discrimination potential, that the policy is not objectively justified in terms of reducing the employee's hours, finding alternative duties, or suspending on full pay in the context of breastfeeding. So if you're looking at indirect sex discrimination issues, so the Ramos case was a similar thing about burden on the employer to show sufficient risk assessment and specific, not generalized assessment, and that's going to be the HSE, so I'm not going to talk too much more on that one. Next slide. Flying through them. Just to be aware, we're all aware of the mental health issues that the present pandemic has probably impacted on individuals quite substantially in terms of those issues. So just want to think about the context in terms of postnatal depression, and the fact that new mothers and pregnant workers have been more isolated than ever. So do bear in mind that 1 in every 10 women have postnatal depression, but it also affects fathers and partners in terms of postnatal depression. Does the person meet the definition of a disability in that context? If the sickness took place outside the protected period, they're not going to be covered in terms of the maternity and pregnancy provisions under the sex discrimination legislation, because their comparator is going to be a male outside the protected period in terms of sick absence. But in the context of whether they meet the definition of a disability under the DDA. And final slide, and then I'm finished, sorry about that, is those two resources are very clear. The pregnancy note on COVID-19, which Kieran drafted actually, is brings out the whole issues around suspending pregnant workers on grounds of health and safety on full pay, and that's probably the big risk factor that you should be looking out for as trade union reps. Protection for suffering any other detriment. So in the context of performance reviews at this time, in terms of how individuals are being treated in that context, and you will have other issues that you may want to look at if an employer has work available to be done, and the only reason why the pregnant worker cannot do or cannot be allowed to do it is health and safety, that should be suspended from work on full pay. And there's also our caring responsibilities in return, which Tony will link to. And I just really, I suppose, the more and more I'm looking at this, is there's new legislation on the horizon in Britain around extending legislation around redundancy. There is huge issues for women in terms of pregnant women and in terms of women on maternity leave, return to work opportunities, and come to our flexible working seminars or come to our new maternity pregnancy seminars, which will be starting in September. So you can have a look at those. Sorry about that for going over time. My apologies.
Not at all. Una, thanks a million for the presentation and for raising so many issues and covering so much ground in such a short time. I am, without further ado, going to invite Sue Spence from the Health and Safety Executive to take the floor, after which we will take a quick comfort break and then back for discussion. So over to you, Sue.
Thanks very much, Claire, and everyone really, and thank you for the invite today. It's a great pleasure and privilege actually to be here. Just to say, my name is Sue Spence. I'm an occupational health specialist nurse practitioner with ECNI, or occupational health professional. Basically, just in English, that I would deal with the health side when we talk about health and safety. So just next slide, please. I will be doing a whirlwind tour because, of course, now as Una and Mother and Helen has mentioned, there is so much information. So what I would say today is I intend to signpost you all to the most specifics, and of course the detail will be in the overheads. Also to say there is a phenomenal amount of information and there are links, and I'll do my best actually to navigate you through today where best to get your information. So what I'm going to cover then, I'm going to talk about the background, and already our other speakers have set the scene with regard to the pandemic, and to say just really how much has changed. Also to say the key elements that I hope you'll take away today is having good communication. That is absolutely vital. Just as human beings, we need to have good communication, but certainly in the workplace with regards to health and safety issues, and of course then with regards to managing pregnancy in the workplace. I'll talk about risk assessment, and of course then more in depth just with regards to the pregnant worker, and whilst there already is provision, then talk more specifically around the COVID areas as well. Also to emphasise risk assessment review, that we just don't stand still as human beings, we just don't stand still, and certainly where pregnancy is concerned, as the pregnancy develops, then certainly risk assessment needs to be reviewed. I'll talk about measures then that need to be put in place to protect the pregnant worker. I've added in as well some questions and answers which have been lifted from our website, and basically just obviously with the time factor, I'll skim over those the subject matter, and certainly you're welcome then to have the overheads. What I would emphasize is that there's help and support out there, and that there's useful links. And certainly when we talk about the adage, we're all in it together, that is certainly the expectation when we talk about COVID, that we all really need to work together. So next slide, please. So my goodness, so much has changed. I remember listening to a radio program on Radio 4, and it was public health specialists a couple of years ago, and they talked about a global pandemic, and they said it's not if, it's when, and no doubt here we are, actually a year into the pandemic. And as our speakers have already mentioned, it has been incredibly hard, because in the early days, this time last year, we were in the middle of a lockdown, and it was actually a firefight, I would describe it. I suppose from a clinical perspective and health and safety background, then there is that side where it's actually an emerging science. At least now, a year later, we can learn the lessons, and albeit very sadly, there have been terrible losses, but at least now I think science and the health and safety world and all those various, the world in general is learning lessons with regards to the pandemic, and there is a significant amount of support and guidance there with regards to managing the pregnant worker. Next slide, please. So I've mentioned already about the firefight, and I've mentioned about trying to keep pace. I feel things are kind of plateauing now. What I would say that with regards to information on managing the pregnant worker, I have the link, and I've interweaved the links throughout the presentation. And of course, as one of the speakers already mentioned, there has been guidance from the Royal College of Obstetricians and Gynecologists. I said that all in one breath. That's the doctors who look after the mums in maternity, the midwives, and of course the doctors that specialise in occupational health or workplace medicine. And these bodies were actually commissioned by the government to specifically look at not only the workplace health issues, but of course they'll be looking, especially from the doctors and midwifery perspective, from the clinical side of things within the hospital and antenatal and postnatal setting. Next slide, please. So really just to say, of course, that we've mentioned already, we've touched on the area with regards to mental health, and really I can't reinforce that enough, and this is where communication is vital. There has been excellent work done. Our public health agency here in Northern Ireland have been working away on the clinical side, and there's excellent guidance, and it's important to signpost your members to these websites, because at the end of the day, the knowledge is power. And when people are more informed, that helps to reduce the anxiety. But being a mum myself and having had a high risk pregnancy, my wee daughter's 8 now, so I can fully appreciate the worry that mums are under, the new mums are under. And then add on top of that, really that the general public population, there's the Office of National Statistics, just recently in March 2020, put out a survey just to say that 4 out of 5 people said that they were very worried really about the pandemic. So as I say, add on the extra layer of being pregnant, then certainly that is a very challenging dynamic. Just to say as well, the ECNI just has developed with the Public Health Agency and our partners a specific risk assessment for the Black, Asian and minority ethnic groups, for vulnerable people, and of course pregnant workers and those returning to work. And this is actually an excellent resource. You probably just can't see it there, you can't actually, but again, I will have that linked as well. It's linked there, but it's also going to be linked on the resources. Next slide, please. So I mentioned already about good communication and how that we are human beings, we are social animals, we need to be communicating. Communication is vital, especially I've come from a nursing background, and it's so vital, but also with regards to managing health and safety. I also worked as a health and safety manager for 7 years in the health trust, and I very much worked alongside the staff side representatives and in our health and safety committees as well, because that was vital, because especially now at the minute, we are all in this together. So when the mum is confirmed she's pregnant, it's important to remind your members that they must inform their employer in writing that they're pregnant, so that a risk assessment can be undertaken, that is the key. And then the mum will act as the go-between, obviously, between the employer providing information. It's important for the employer to communicate with the mum, and similarly too, it's important for the mum to communicate with the employer, just to make them aware if there's any changes with regards to their health need, and of course then to the risk assessment. So next slide, please. So just when we talk about estimating pregnancy and risk, of course now we have different layers when we talk about risk assessment, and there has been significant work done with regards to determining the level of risk that a pregnant worker may be exposed to. So as a standard then, a pregnant worker would be seen as clinically vulnerable. And the reason for that being is that they may just be more susceptible of infection. But the other thing as well to say is that we can't lose sight of the fact of those other risks that there are in the workplace. There's no doubt that COVID has taken over, and rightly so, but that basically a pregnant worker will be still exposed to those issues with regards to certain chemicals, or maybe standing for long periods of time and getting tired, and those things, the standard pregnant worker risk assessment needs to be undertaken. The other thing to say, which I very much preach, is that when employees come into the workplace, they're not gift wrapped. They don't come in like a doll or a machine. They are human beings, and with that then they will bring with them a history, and of course then there will be pregnant workers who will have underlying medical conditions, and in that case they'll be classed as clinically extremely vulnerable. And then what you're talking about shielding then in that case, and ideally if they can work from home, that would be the direction of travel, and if they can't, then the employer needs to make put systems in place. But really the other thing to say as well, that with regards to categorizing people, and I hate to use that word categorizing because we're all human beings, that there will be people who will not just be in one category or another category, that there'll have to be a clinical decision made as to whether they are to shield, and that would be for the employee then to work with their GP, hospital clinicians and maternity services. Also with regards to shielding, there's excellent advice on the NI Direct website and on vulnerability, and I've put that link through, and this advice is excellent as well. As I say, the better to be informed, as I say, and knowledge is power. So the next slide, please. So I've mentioned already about clinically extremely vulnerable, and I've mentioned already it's about taking the latest advice. And of course now, as we are being released is probably the way to put it, then people are being allowed back into the normal environment, and we have to be mindful. We all have to be mindful that whilst the levels are lower with regards to COVID and the infection spread, that we have these other gremlins coming through now. We have the Indian variant, which was this morning, I heard on the news, was to be seen as a variant of concern, but actually the one that, from my understanding, that has created a lot of problems here has been the Kent variant. So regardless of the variant, and without going into detail, it's still important that even though we have these vaccinations, that there's never going to be a silver bullet with these things, and there has to be really a combination of preventative measures, not just to protect the employee, the pregnant employee, but to protect everyone. So next slide, please. So I'm sorry the slide is busy, but really, again, there's information here that hopefully you'll be able to take away today. It was quite interesting actually, because when I did my NEBOSH certificate, and we talked about the health and safety at work order, which, as we know, is the mother of all health and safety. It's actually the mother of all health and safety legislation. So it's quite apt this morning to talk about the mother. And of course, so way back in 1978, it was actually alluded that we needed to carry out risk assessment, but it didn't tell us how to do it. It was there to promote, encourage, and stimulate safety in the workplace. So it was really then about, it was 1992, so they had the six-pack, and basically that's where we had the management of health and safety at work regulations, and that specifically talks about risk assessment, because you're well aware that is the cornerstone, and we've already had conversations coming through where risk assessments aren't being undertaken. And apart from anything else, it is a legislative requirement, and it's a terrible pity, because having relied on it heavily, especially in my role as a corporate safety manager within the Health Trust, it is an excellent way. It's a systematic approach to managing risk, and of course, in this case, the pregnant worker. But this legislation, the management of health and safety work regulations, then it talked about the new and expected mother. So it wasn't just about the pregnant worker. It was actually about the pregnant worker and the mum who's given birth in the past 6 weeks, and also those who are breastfeeding. And again, I've signposted you to the article, the information with regards to the new and expectant mother. So just to recap with regards, and also, I should mention that the likes of the workplace regulations or the welfare regulations, they need to be taken into consideration, because when ladies are pregnant, they need to be close to, they may have to sit down for a while and rest, and also close to the toilet and that, and similarly to, that if the person is breastfeeding, there needs to be certain measures in place as well. So just to talk about the risk assessment itself, as mentioned already, the employer needs to take in the latest medical advice. They need to speak to the employee and see really where they are and what they can do with regards to the job role. And of course, there are organisations that would have occupational health input, and especially, or should I say, it's a luxury for people that don't, for those that don't have it. But certainly with regards to the health service, the occupational health input would be very important, because with the healthcare workers that would be actually really frontline and dealing with the COVID and nursing these patients, it's important that there is that extra advice, and of course there is guidance on that. So as I say, it's really about the employer needs to put preventative and protective measures in place, and they need to take into consideration the public health guidelines as well, both nationally and locally. So just to say, with regards to risk assessment then, so basically there should be a standard risk assessment in place for the general work area. And again, there's a template for that on the HSE website, our website, and GB, which is due to be updated. There's also then information with regards to pregnancy. So there needs to be their standard risk assessment. You need to have your pregnancy risk assessment to cover all the pregnancy risks. And then there needs to be a risk assessment, or tie that in with the risks that are presented from COVID. And again, to reinforce, the information is there. There's an excellent template there for the Black and Asian minority ethnic group, the vulnerable people, and pregnant workers. And that's on the Public Health Agency website, but it can be linked through from our website. So next slide, please. So just some measures then, just to remind us then, how then can we protect the pregnant worker from COVID? And of course then to say, the key really is about reducing interaction with people. At the end of this day, how COVID has been transmitted is through aerosol, through coughing and sneezing. And of course, then that is why we were all locked down last year, is so that we were only within our bubbles and that we weren't interacting. But the key is very much for the pregnant worker that we need to limit that, reduce the interaction, and of course then maybe consider the likes of non-client facing roles. Just simple things like adjusting their start time and finishing time and break times so that they're not really mixing with other people. And of course, as we mentioned about the mental health, that is incredibly difficult because as a new mum, there is that thing of socialization, and you know, but that we have to be considered, obviously, to keep them safe that there isn't that same interaction. Adjusting the workload, because as a pregnant mum, they are going to be that bit more tireder, and making the work lighter. And that is very much applicable when we talk about the general pregnancy or the individual risk assessment beyond COVID, where you'll be looking at things such as moving and handling. Really, of course, as we know, there's so many physiological changes with pregnancy and hormone changes where the bones can become that bit softer. And if the person maybe is in a posture for a long period of time, or maybe has to move items or things, then they're at greater risk then of injury. So all those things need to be considered for the pregnant worker as a person from a COVID perspective and from those other pregnancy risks as well. So next slide, please. So then, of course, we need to be thinking about the provision of face coverings, and of course with that the surgical masks. And again, of course, I mentioned again, I can't reinforce enough, limited interaction. And the main thing, of course, which is an excellent adage, is hands, face and space. And yes, whilst we're moving out of lockdown now and there's talk about the space being reduced and everything else, the hands, face and space has been the way to go. Good hand hygiene, the face masks and the 2 metre rule. And of course then I've just repeated there to check out the standard general risk assessment with regards to the workplace from the ECNI website. And again, specific individual pregnant worker COVID risk assessment is there, but you need to consider also those other risks too. Okay, next slide, please. So the other thing is, as I know some of our speakers already mentioned, and this is something that I just find is just so important. Again, having come from a nursing background, when you're dealing with a patient, then you would have care plans and you're reviewing the person and whether their condition, dear love them, if they improve. And having worked in Marie Curie, then maybe people then just they don't, there's may not be able to improve them medically, but certainly you can make them more comfortable. And within the health, in the workplace space, it's important that risk assessments are reviewed for all the different risk assessments, but certainly for pregnancy, because when you think about it, as a lady, as the pregnancy progresses, so too will the person's ability to do certain things. And with that then as well, as the coronavirus evolves, it's important to review. And with the new evidence that's emerging, it's important to review. And what I should say, and apologies, that throughout the risk assessment process, it needs to be shared with the lady. There needs to be that good communication with the employer. It's okay, so next slide, please. So this is where my colleagues have already mentioned already, and they're better people than I to talk about this, but we talk about a sliding scale, and basically, obviously, if the workplace can't be altered then, if there's not a suitable alternative, then the lady would need to go off on full pay. And I was very sorry to hear about those terrible situations, because it is such a worrying time to be pregnant, and just personally, to think that maybe that these people have those terrible money worries as well. Okay, so next slide, please. So just really to recap with regards to the employer and the employee's duty. And again, for your members, when you're talking to your staff on the ground, everybody has a part to play. The pregnant worker must inform the employer in writing that they are pregnant in order for the risk assessment to be undertaken. The risk assessment needs to consider the preventative and protective measures to protect that person, taking into consideration the specific work environment, the risk of infection precautions, and any measures that the government have put forward with regards to national and local recommendations. The responsibility for the risk assessment is with the employer, and that needs to be shared. And of course, then with pregnancy could become more complicated, or there may be a person who is clinically extremely vulnerable. And again, if the employer has the luxury of having an occupational health provider, that is excellent. But the main thing as well is that the lady then getting advice, the lady through her antenatal services, through her doctors and midwives, and also with regards to COVID, even just ringing the 111 number for advice, because that is a specialist number with regards to COVID as well. And the Public Health Agency have a GD room as well, which I should have mentioned actually. So just the next slide, please. So this is the Q&A time now, and I'm just going to whirl through because I'm not sure how we're fixed for time, because to be honest, once I started working on this subject, I could have talked for 2 hours, but anyway, my husband would say that's normal for me. But anyway, so next slide, please. So this is very important because this is where we talk about the level of risk again. And in actual fact, with regards to the pregnancy, we talk about trimesters. So doesn't matter what stage in the pregnancy a worker is at. Well, yes, it does. If the lady is in the first or second trimester, which is less than 28 weeks, and they've no underlying serious health conditions, and there is social distancing practice, hands, face, and space, and the guidance is followed in the risk assessment, and it shows that the person is safe to work. But again, that is very much dependent on the clinical advice from the midwife, the GP, the maternity services, and of course then you would add in additional controls as is required with regards to PPE or whatever the risk assessment has demonstrated. So next slide, please. And of course then, as the pregnancy progresses, then the lady will become more vulnerable, and that is simply from the perspective of the fact that the lady then, the baby's getting bigger and the body has that much more work to do. So this is where there's a risk that the lady could become iller. But in actual fact, I was speaking, a friend of mine is a midwife, dear lover, and she works in the labour ward. And my goodness, she was telling me just about how they are trying to navigate through at the minute. And I feel very sorry for the mums. And I think that's important to say to your members as well, that we as human beings, the healthcare sector, we're all empathetic with regards to the needs of the pregnant worker. And my friend was saying really that it's awful then that the dads have to wait until the mum is at a certain level of developed in the labour for the father even to come in to the labour room, that they have to sit out in the car, and that's very, very hard. So anyway, after 28 weeks then, we've seen that the pregnant lady would be seen as that bit more vulnerable. And again, it's important that they adhere to, and the employer makes sure that the social distancing guidelines are in place. And of course then, if the risks are higher, then it may well be more suitable that that person is advised to remain at home. And really the government message is that where possible, as far as I'm aware, you still remain at home. So the next slide, please. And then finally then, when we're talking about return to work, again, it's down to risk assessment. It's down again to very much taking the medical and the clinical advice really with regards to return to work, or whether or not that lady needs to stay at home. So just the next slide, please. And that's the same again with return to work, and just the next slide then is links. Okay, so just to recap, basically with regards to pregnancy in the workplace, managing risk, as we know, is not a new thing. It's actually alluded to in 1978. You have the Management of Health and Safety at Work regulations, which specifies really that risk assessments need to be undertaken for the new and expectant mother. So as a standard approach, we need to have risk assessments in place, and we need then to have an individual risk assessment for that new mum. Within that then as well, because we have COVID, we have all those other issues what we should not be forgetting about with regards to pregnancy and those other workplace risks. And then on top of that, there needs to be provision made for the pregnancy as well as part of the individual risk assessment. I have to say, I've just pulled together some excellent documentation. And I just want to say, I mean, even just the leaflets are excellent on the websites. There's one there, the new and expectant mother, and that is excellent because that gives you your general summary with regards to the needs of a pregnant worker. And then moving into the more specialist information, again, from the Royal Colleges, and also then the fact that there are templates as well with regards to the standard risk assessment for the environment. And then, of course, there's a template available, which is excellent for vulnerable workers to include the pregnant worker. And so really just to say that, as I said, the advice is available. You've got the Public Health Agency, you've got the 111 number. You also have the advice on our website as well, and HSEGB. And of course, with that then, basically just as I say, I can't reinforce enough how important it is that there is good communication. So thanks very much, everybody. That's it. Thank you.
Thank you so much. Sue, again, a really